history of emergency powers. Perhaps the most famous example is Adolf Hitler's invocation of emergency powers to dissolve the German legislature and destroy the German Republic. I want to thank my good friend and Salon member Tim Worth for sounding the emergency powers alarm in the United States last year. Tim collaborated with my college classmate Joel McCleary, who's on tonight, along with Mark Medish and Gary Hart and others, to found the nonprofit Keep Our Republic. Keep Our Republic shares the committee's alarm over limitless power that crowns the office of the president greater than the provocation for the American Revolution. We welcome Tim, Joel, and Mark tonight. Committee members have participated in dozens of salons during our seemingly permanent 9/11 legal state of emergency, in which the president wages perpetual war against international terrorism, playing prosecutor, judge, jury, and executioner to kill any person on the planet. Trump bombed Syria twice during his administration without congressional authority, in violation of the Constitution's declare war clause. It only took Joe Biden 31 days as president to follow in Trump's unconstitutional footsteps. Tonight's salons spotlights the emergency powers our imperial presidency exercises at home. Whether at home or abroad, emergency powers spring from congressional abdication. Keep Our Republic and the Committee for the Republic agree that repealing unconstitutional delegations of emergency powers must be a top priority for the 117th Congress. Tonight, welcome America's leading legal scholar on emergency powers. Liza Goitein is the co-director of the Brennan Center at New York University Law School. Liza isn't intimidated by unchartered legal waters. She is an expert on the paradigm of all emergency power statutes, the open-ended National Emergency Act. Liza will tell us how we can step back from the precipice of rule by executive decree. Without further ado, join me in welcoming Liza.
Thank you. Thank you so much for that very kind introduction and for giving me the opportunity to have this conversation with all of you. Emergency powers is a topic that I've been studying since approximately November 9th, 2016, not to put too fine a point on it. The program that I direct at the Brennan Center, the Liberty and National Security Program, was founded to grapple with various violations and erosions of civil liberties that took place in the wake of 9/11. In November of 2016, I found myself wondering what President Trump would do if something like 9/11 happened on his watch, and my obsession with emergency powers was born. So I want to start with a very basic but important question, which is, what are emergency powers and why do we have them? I mean, it's not just the fact that somebody sticks the word emergency into the law. Emergency powers are not a new phenomenon by any means. They've existed in countries around the world for hundreds of years, going all the way back to ancient Rome. And the argument for this is this: because emergencies are by definition unforeseeable and unforeseen, the powers conferred on the government by existing laws might be insufficient to address them, to respond to the emergency. And amending the law to provide greater powers or different powers might take too long. And it might do damage to some principles that are considered to be sacrosanct in ordinary times. So emergency powers authorize a limited departure from the legal norm, and their purpose is to give the government, usually the president, the prime minister, the head of state, a temporary boost in power until the emergency passes or until there's time to change the law through the usual legislative process. While the concept might seem simple enough, emergency powers can mean many different things in practice. So the Constitution of ancient Rome, as I mentioned, contained provisions for emergency powers. There was an elaborate system of checks and balances in ordinary times to safeguard citizens' rights. It was very advanced in that way. But during emergencies, the Roman Senate could direct the two top executive officials to appoint a constitutional dictator who would exercise near absolute power for a period of up to 6 months. And over a 300-year period, this provision was invoked 95 times, usually in response to outside invasions. Modern constitutions also tend to include special ground rules for emergencies. There are 178 countries whose constitutions make some sort of special provision for emergency rule, but rather than giving all power over to a specially appointed dictator, they generally enhance the power of the existing head of state by allowing him or her to suspend some or all of the rights that the Constitution gives the people, often with various checks put in place, like a time limit or a requirement that the legislature approve the emergency. The US Constitution is a bit of an outlier, actually, because it doesn't have any separate regime for emergencies. It does contain a handful of provisions that could be viewed as a kind of crisis response power, but these provisions are vested in Congress, not in the president. So most notably, the Constitution authorizes Congress to suspend habeas corpus in times of rebellion or invasion. And the Constitution authorizes Congress to provide for calling forth the militia to execute the laws of the Union, suppress insurrections, and repel invasions. Given the dearth of express emergency powers given to the president in the Constitution, Congress has historically stepped in and legislated special powers that the president can call on during military, economic, or labor crises. Up through the early 20th century, this was done on a sort of ad hoc basis, but starting around World War I, a system evolved by which the president would proclaim a state of emergency when he saw fit, and then that would trigger legislative powers that would otherwise lie dormant. So that's sort of how it worked, but for several decades, there was no overarching law that governed this process. It sort of evolved organically. Presidents didn't have to identify what powers they were invoking or keep Congress informed of their actions, and states of emergency could and did last indefinitely. Then came Watergate, the bombing of Cambodia, and a whole slew of other executive abuses, which plunged Congress into a sort of existential reckoning over the extent of executive power. A special committee was formed in the Senate, members of whom might be on this call, to look at emergency powers. And they discovered that there were 4 clearly obsolete states of emergency still in effect, including, and remember that this is in the early mid-1970s, FDR's bank holiday from 1933 that national emergency was still in effect. So was the 1950 declaration from the Korean War, which was actually being leveraged to prosecute the war in Vietnam. They also discovered that there were hundreds of statutory provisions on the books that the president could activate in an emergency. In the committee's words, these included some extraordinary powers to seize, I'm reading the quote, powers to seize property and commodities, seize control of transportation and communications, organize and control the means of production, assign military forces abroad, and restrict travel. So a wide swath of powers. The committee's solution was the National Emergencies Act, which Congress passed in 1976 and which still governs national emergencies today. Quite honestly, given the depth of the committee's concerns about emergency powers, it's a bit perplexing how modest this law was in its ambitions. It includes no definition of national emergency, no criteria that have to be met or factual showings that have to be made, nor is there any firm limit on how long a state of emergency can last. Congress also left the vast majority of powers that become available to the president during a national emergency intact. There were basically 3 ways that the law did set out to limit presidential emergency powers. First, it provided that emergency declarations would automatically expire after a year unless the president renewed them. Second, it allowed Congress to terminate emergency declarations using a concurrent resolution, so-called legislative veto, which is a law that goes into effect with a simple majority of Congress without the president's signature. And third, it required Congress to meet every 6 months while a state of emergency was in effect to consider a vote on whether it should be terminated. So those were the main reforms. By any measure, the law has failed. Renewal after 1 year, which was, expiration after 1 year was supposed to be the default. Renewal was meant to be the exception, but it has become standard. So most emergencies today last for a decade or more. We are still in a state of emergency over the Iranian hostage crisis of 1979. As for the legislative veto provision, the Supreme Court held in 1983 that these were unconstitutional. So today, if Congress wants to terminate an emergency declaration, it effectively has to muster a veto-proof supermajority, 2/3 in both houses in order to do it, which is all but impossible in today's hyper-partisan environment. And until 2019, Congress literally ignored the requirement to meet every 6 months to consider votes on termination of existing emergencies. As a result, we are in 40 different states of emergency today. These emergency declarations give the president access to powers contained in more than 120 different provisions of law that the Brennan Center identified in a project back in 2018. You can find them on our website. For the most part, the president is free to invoke any of them. There's no requirement in the National Emergencies Act that the power that's invoked has to relate in some way to the nature of the emergency. Now, it's important to acknowledge that many of the individual emergency powers, the 120 plus powers, seem quite measured and reasonable on their face. So, for example, there's a law that allows the Department of Transportation to set aside weight limits on highways to allow trucks to carry jet fuel, more jet fuel to Air Force bases, things like that. However, there are a few powers where the potential for abuse is quite stunning. One of the scariest, in my view, is a law dating from 1942 that allows the president to take over or shut down radio stations and radio communications facilities in an emergency, in what he declares to be a national emergency. If he goes further and declares a threat of war, there's no procedure for that. He just says there's a threat of war. He can go further and shut down wire communications facilities or take over wire communications facilities. This provision was last invoked during World War II when wire communications were telephones and telegraph communications. And this was at a time when fewer than half of American households actually had telephones. Today, it could be interpreted to include the internet and to essentially give the president control over US-based internet traffic. Another scary emergency power, in my view, is the International Emergency Economic Powers Act, or IEPA. So this is another law that the president can access if he declares a national emergency. Under this law, if he declares a national emergency to deal with any, quote, unusual and extraordinary threat which has its source in whole or substantial part outside the United States, to the national security, foreign policy, or economy of the United States. So that's the criterion. At that point, if he declares an emergency of that nature, he can basically freeze any asset or block any transaction with respect to property that's subject to US jurisdiction, which is a lot of property. This law has mostly been used to implement sanctions against hostile foreign actors. And in that sense, it's been used fairly narrowly, albeit a lot. But on its face, it allows the government to do much more. And in particular, there's nothing in the law that stops the government from deploying it against Americans who are deemed by the executive branch to be contributing in some way to a foreign or partially foreign threat. And at that point, the government could literally make it a crime for anyone to rent a house to that person, to give that person a job, or even to sell them a loaf of bread. So what's most remarkable in some ways about this whole system of emergency powers is, quite frankly, how little abuse we've seen until recently. Presidents have actually shown remarkable restraint in using these powers. At the Brennan Center, we crunched the numbers and found that 70% of the provisions had never been used, or since the enactment of the National Emergencies Act. It might seem a little odd to describe presidential use of emergency powers as restrained, given that 70 states of emergency have been declared in a 43-year period. 64 of those declarations, though, were declarations under the International Emergency Economic Powers Act, IEPA, which kind of have to be considered separately. And that's because almost from the very beginning, presidents treated IEPA as a general delegation of foreign sanctions authority rather than an emergency power. It's consistently been used to advance foreign policy goals, regardless of whether there's a true emergency. And while that's not a great thing, the reality is that Congress is quite happy to have the president take over the foreign sanctions portfolio. It's a delegation of foreign sanctions authority that's masquerading somewhat pointlessly as an emergency power. Outside of the IEPA context, declarations of national emergencies have been few and far between. Other than the border wall declaration, there have been only 6. There were 3 that addressed foreign attacks or invasions, 1 that addressed a hurricane, and 2 that addressed epidemics, health epidemics, and that's it. President Trump unfortunately broke the seal with his declaration of a national emergency at the southern border. You can argue over whether or not unlawful border crossings are an emergency. I'll point out that even though the National Emergencies Act doesn't define the term emergency, the word does have a dictionary definition, and that definition includes the element of surprise. An emergency, by definition, is sudden or unexpected. And I would submit that there was nothing sudden or unexpected happening at the southern border in 2019. But what you can't argue about is the fact that the president was using the declaration for the express purpose, the admitted purpose of getting around Congress, which had repeatedly and consistently refused to provide funding for the border wall at the levels the president wanted. Since the enactment of the National Emergencies Act, no previous president has declared a national emergency for that purpose. And it obviously creates major concern and issues with regard to the separation of powers. There's actually some good news here. As a result of Trump's abuse of powers, combined with the advocacy of several people on this call, Congress is poised to revisit the National Emergencies Act for the first time in 40 years. There's legislation pending that would require presidentially declared emergencies to expire automatically after 30 days unless Congress affirmatively voted to approve them. There is remarkably broad bipartisan support for this reform, actually, in an era in which bipartisan support is very hard to come by. So I am hopeful, if not optimistic, that we could potentially see this legislation enacted in this Congress. I want to switch focus now from the National Emergencies Act to constitutional emergency powers. I know I said earlier that the Constitution doesn't give the president any express emergency powers. That hasn't stopped modern presidents from, and some legal scholars as well, from claiming that Article 2 of the Constitution gives presidents vast implied inherent emergency powers. Some believe the president has these powers by virtue of being the commander-in-chief of the armed forces. Others believe the executive power itself implies the ability to respond to emergencies. And whether Congress can actually limit these implied powers, assuming they exist, is a matter of some scholarly debate. Unfortunately, the Supreme Court has not provided a whole lot of specific guidance when it comes to this notion of inherent emergency powers. The court just hasn't exercised or just hasn't addressed the exercise of emergency powers very often. And when it has, it's generally tried to resolve the issue on the narrowest possible grounds that it can. There are a few overarching principles that can be derived from the case law. First and foremost, the president is bound by the Constitution at all times during emergencies as well as otherwise. His actions are on stronger legal footing when they are expressly authorized by Congress, and he can act against Congress's will only when Congress has literally no jurisdiction over the subject matter. If the constitutional rights of Americans are implicated, then the courts necessarily have a role to play. Within those broad parameters, the outer bounds of the president's constitutional authority when responding to emergencies remains poorly defined. And really, one can find threads in the case law to support almost any theory, unfortunately. If the scope of constitutional emergency powers were to come before the court today, we don't know what the court would hold. Obviously, a lot would depend on the particular facts of the case. We do know that there are 5 and possibly 6 justices on the court who are going to be extremely deferential to claims of presidential authority in areas touching in any way on national security or foreign relations or war. How broadly the president and the court interpret constitutional emergency powers is ultimately, in my view, probably more important than whether Congress reforms the National Emergencies Act. And that's because in the few cases in our nation's history where there has been flagrant abuse of emergency powers in ways that touch on basic human rights and liberties, the presidents in those cases have relied on implied constitutional powers, not statutory authorization. The internment of Japanese Americans during World War II, the CIA's program of torture after 9/11, the NSA's program of warrantless wiretapping, all of these relied primarily on claims of inherent Article II authority. So if history is any guide, although these days, who knows, that's where the greatest danger lies. This leads me to my final topic, which is presidential emergency action documents. These documents, I will refer to them as PEADs, are executive orders and directives that are drafted in anticipation of a broad range of worst case emergency scenarios with the idea that they'll be ready to go, ready for the president's signature if one of these emergency scenarios were actually to come to pass. They originated during the Eisenhower administration as part of planning for continuity of government in the wake of a Soviet nuclear attack. But they've expanded over the decades to address other types of emergency as well. PEADs are shrouded in extraordinary secrecy. Over the course of these 7 decades that they've existed, not one has ever been released or even leaked. Still, we know a little bit about their contents from other official records, FBI memos, and the like that have been made public. From these records, we know that PEADs up through about 1970 purported to authorize martial law, the suspension of habeas corpus by the president, not by Congress, as provided in the Constitution, censorship of the press, warrantless seizure of property, and the roundup and detention of quote unquote subversives inside the United States. We know much less about the contents of current PEADs. The documents undergo periodic revision, and there were apparently some major revisions in the 1980s. But we do know that they exist, that there are somewhere around 50 of them today, and that as of 2018, at least, they were undergoing another periodic revision by the Trump administration. Let me hasten to say that planning for emergencies is not a bad idea. I think if this pandemic has taught us nothing else, it's taught us that advanced planning can be a very good thing. Teeing up the measures that might be necessary, including templates for orders and directives that would put them in place, is not only appropriate, but prudent. The concern with presidential emergency action documents is twofold. First, at least historically, these documents would have implemented measures that are unconstitutional. And it's never acceptable for the government to plan for violations of the Constitution. Second, and relatedly, these documents are unilateral assertions of power that are subject to no oversight whatsoever. In particular, they are not shared with the Congress. And that's quite extraordinary when you consider that even the most highly classified covert military and intelligence operations have to be shared with the so-called Gang of Eight, and yet these documents are not. A colleague and I wrote an op-ed about these documents in the New York Times in April of last year. Gary Hart followed up with an op-ed of his own. This piqued the interest of lawmakers. And so there is now legislation pending that would require the president to disclose PIADs to the relevant committees of Congress to enable oversight. And again, I think there's some reason for cautious optimism that this common sense reform will actually become law. So I will end my opening remarks on that hopeful note, and we can open this up for a conversation.
Well, this is Bruce. I think that's been a masterful survey of emergency power. So I want to give you the highest compliments. Certainly better than anything we could get at a statement in the congressional record by a member of Congress.
Thank you.
But put aside a couple of initial observations. One, with regard to planning for emergencies, you rightfully said it makes sense to do that. But there's no reason why Congress can't plan for emergencies as well. I remember with the Church Committee in 1975, in the Foreign Intelligence Surveillance Act, they put a big list. In time of war, the warrant requirement for surveillance is suspended for 14 days. And at that period of time, the president can come to the Congress and seek an extension or seek some modification of the law. There's no reason why Congress doesn't have the resources and the time to plan without any presidential involvement at all. A second observation relates to the, your statement that the Supreme Court has only given very, very sketchy decisions with regard to emergency powers. But if you go back to the founding years, Chief Justice John Marshall repeatedly proclaimed, especially in the quasi-war with France, that Congress has the say on the authority in a so-called emergency. This was with a conflict with France, what powers the president could exercise in retaliation, intercepting ships that are going to France or returning from France. He made it quite clear that Congress was plenary in this field and the president was subordinate. The precedents are there, but they're just ignored because, in my view, we've cast aside the Republican thinking of the founding in favor of an empire, where you can't run an empire unless you have unity of command that operates with a limitless power. It's exactly what you described happened when the Roman Republic descended into a dictatorship. There's a couple of observations, but yield the floor to other questions. But I want to compliment you again. A truly fabulous presentation.
Thank you so much.
Tim Worth, I said before you got on, if you can unmute yourself, that you first brought this to my attention. You and Joel called me, and we talked about emergency powers. And Boyden and I have been talking for some time, and Bruce, about having a delegation doctrine, Panama refining, Schechter poultry, the whole broader issue. But the emergency powers is a nice subset of delegation doctrine, and so that's why we jumped on this with Lisa and all this great work she's done. So Tim, you and Mark and Joel, why don't you jump in and tell us about Keep Our Republic and how you stumbled on to how you came to you put us on to Lisa. What your thinking was in starting Keep Our Republic.
Joel, why don't you jump in here?
Well, I'll just say a word or two about how I got involved with this. And that was through my cousin and mentor, Bill Miller, Ambassador Bill Miller, whom I'm sure many of you all know. He was ambassador to Ukraine, but Bill had been staff director of the Church Committee and had been staff director of the Senate Select Committee on Emergency Powers, and also had been key in drafting actually the War Powers Act. And when I was a young man, we used to go up to Rhode Island, and every summer we would spend time talking about this, and he would have me read the various Senate reports, particularly from the Church Committee. And then, so I was interested in it and interested in the work that he was doing. And later on, I did a report for Homeland Security on biological weapons. And in the course of that, obviously started to look at the need for emergency powers in case someone launched a nuclear equivalent biological weapon. And so started to talk to Bill about the powers then. And then Mark Medish and I, Bill got sick, and shortly before he died, we went to see him and talked to him about many issues that we hoped that he would talk to us about, since he was a great keeper of secrets. But he really asked us to bring this issue up, because he was extremely worried about what was unfolding and the direction the country is going, and wanted to write an op-ed. Unfortunately, he died right beforehand, but he made us make a commitment that we would get involved with this issue. And so that's how I got involved, and I recruited Tim and Mark and I did. And of course, Tim really gave the Republic Committee just tremendous, attracted many different people to it and helped us get it organized. So, and of course, the Brennan Center has done really the foundational work, and I really applaud what they've done. And we consider ourselves lieutenants under Elizabeth's in her army, and I think she is doing unbelievably great work on the Hill that we all need to take a great look at and to support the best we can. Mark, you want to say a word, and then we'll let him.
No, that was perfect, Joel. And just our colleague Gary Hart, who I don't think has been able to join us, was of course a member of the Church Committee and has done yeoman's work on this issue for decades. Liza has just done really path-breaking analysis, bringing the information into public view. I mean, a lot of this has just passed in the dark of the night, both the congressional sort of dereliction of not reviewing emergency powers that have been delegated, but then the murkier box, which Liza ended on, which is the Article 2 powers, the kind of blanket assertion of inherent executive powers that may go as far as suspending clauses of the Constitution, which for me are really the most worrying aspect of this. And I think there was Liza, you may want to go, there was an executive order in the summer after the riots, after George Floyd, where it seemed that the White House was invoking Article 2 powers and mandating DHS and other agencies to sort of protect federal properties and statues and all that. And yeah, do you want to? It was vague. Yeah, but yeah. Go ahead.
Yeah, that there was a brief period of confusion where it wasn't very clear on what authority they were there. It ultimately was clarified, and I learned a lot during that period about, because I had been studying as part of my focus on emergency powers. I have focused on authorities to deploy the military domestically, which there's a set of there are laws that are not technically emergency powers because they don't require an emergency declaration, but you really have to view them as extraordinary powers because as emergency powers, because they authorize extraordinary authority that's to be used in extraordinary circumstances. And the example I would give is the Insurrection Act. So, which allows the domestic deployment of the military to put down civil disturbances. And I've been taking a lot of look at those domestic deployment authorities. I knew much about the laws that give the president tremendous authority to move federal law enforcement around from one area of jurisdiction to another. So you would never expect that the Customs and Border Protection agents would have any jurisdiction to show up in Portland and guard the courthouse, but they can be deputized to serve as members of the Federal Protective Service. And even if it's clear that protecting federal property is not quite what they're doing, That part is very difficult to prove. Federal property is everywhere, right? Federal laws are everywhere. So in theory, federal law enforcement can go where they're not wanted. So ultimately, it looks like it ended up not being a claim of Article 2 authority, but it ended up, for me, highlighting some very problematic delegations, again, of statutory federal law enforcement.
Thank you.
Good. Good.
Uh,
Boyden?
Questions?
John, let me
Boyden?
say a couple more. Go ahead.
Sure.
Go ahead, Mark.
Absolutely. Go ahead.
No, go ahead.
John, let me say a couple more words about Keep Our Republic. When Joel and Mark and I came together and organized this group, we had two deep concerns. One was the 12th Amendment and the possible abuses of that. And the second one was that the president would invoke one of the emergency powers at one point or another during the fall election or soon thereafter. I think we know what happened related to the 12th Amendment and the problems with that. And there's a tremendous amount of literature and great numbers of people working on that set of issues now. On the emergency powers, this may be a good time. It's a quiet time to readdress the question of emergency powers. My own belief is that we dodged a bullet, that the incompetence of the Trump people in terms of launching their coup was such that they did not figure out how to use their emergency powers and when to use them, and that we were very lucky to avoid that, and that it's now a good time for us to readdress this. We have open discussions with members of the judiciary committees and to try to get them to really address these issues, and at least we ought to have an illumination of them. Seems to me that's a pretty clear first step, to ask the committees to do so. They have really shied away from that, and maybe with the Biden administration, they may not want to do it. They may want to leave left alone and have the Biden people have all of the authorities that they currently have without illumination. I think that that's a mistake. I think that we ought to continue to be asking these questions and know what they're about, and the Congress, ought to know what it is that the administration is authorized to do and what it's not authorized to do. And going back to Bruce's, of course, sharp questions, how do we answer those? So it remains a question for us at Keep Our Republic, our small but focus group with Mark and Joel and Gary Hart and Dick Gebhardt and Charlie Curtis and a number of others. We will continue to focus on this and a few other issues that we think leave major holes in the election process and leave real vulnerabilities for us as a democracy in 2022 and 2024. So thank you very much for putting this together, John. Really appreciate it. It's always good. Eliza, you do a beautiful job as ever. We're all deeply indebted to you for your fine scholarship and extraordinarily articulate way of putting all of this together. Thank you very much again.
Thank you for the work you've done to actually advance the ball and move towards a solution in Congress. Just a word about the politics of this. I was amazed, actually, after President Trump declared a national emergency for the border wall. I was amazed at the breadth of support from Republican lawmakers for reforming emergency powers. And the major legislative vehicle still to this day comes from the bill that Senator Lee introduced, that he got 18 Republican co-sponsors on in the Senate. And it's deep, meaningful reform of emergency powers. And for a moment, I was worried that the Democrats wouldn't support it because it was a Republican bill, but they were very supportive of it too. And that approach, basically that legislation was picked up and placed into two major Democratic reform packages that are still very much on the table.
I could suggest a parallel approach that you've undertaken here with Congress, and that is, I think there needs to be also an approach to executive officials, both incumbents and during confirmation hearings, and extract from them pledges that they will disobey a clearly unconstitutional illegal order. It's required of members of the military. And I think one of the checks that prevented Trump from moving forward, despite his ambitions to stay in office, was he had a worry that his orders would be disobeyed. There was some clear resistance after the Lafayette Park debacle from the Defense Department. But it seems to me we need to get a culture within government officials. You do not obey clearly unconstitutional orders. And a primary way to extract that pledge is at confirmation hearings. I would think it would be appropriate for the senator to have a rule. We don't confirm
Is
anything
this one open?
that doesn't make a pledge
Could you give me
like that.
quarters, please?
I couldn't tell who that was. Boyden, you want to jump in here? We've been talking about doing delegation doctrine, why Congress is not doing its job, and this is a subset of it. But we thought the emergency powers is a wonderful way to get into this broader subject. Your thing is down in the corner, Boyden. I think in the bottom left-hand corner. There you go. You got it.
Well, I'm surprised but not shocked about how much agreement I have with the speaker tonight. My main point would be, in answer to your question, there's an enormous opportunity for bipartisan cooperation on this question of emergency executive authority. I'm not sure I have any real major disagreement with anything she said. So well done. We may find ourselves at odds later, maybe, but that was really, really good. And I think that we need to corral our resources on both sides of the aisle about unconstitutional presidential assertions of authority, of which there have been many and continue to be some, even by the current administration with the attacks on Syria. And I think it's time to call an end to all this. And so I'm so pleased by this presentation that I don't really know how else to respond without being redundant or irrelevant.
So Andrew Coburn, I see you're here. Andrew, you wrote a long article about this in Harper's last year.
Well, I did. I mean, I can't really add to the, all the very, very sound points that have been made by Lisa and everyone else. I would just say that, I mean, I spent a lot of that article commenting on the last great opportunity that Congress had to really deal with emergency powers back in the Watergate era in the mid-70s, and they really completely blew it. Well, they blew it. There was the thing that Bill was involved in, the Emergency Powers Act, the 1976 Act, was great, but Congress then sort of withdrew from the field. And so, you know, my hope would be that maybe this time, even though the immediate crisis of Trump has receded, at least for a few years, we hope, that, you know, this time, you know, as has been expressed already, that people will, you know, that the pressure will keep on, that these fundamental sort of landmine in the path of the constitutional government be removed. I'll just say one other thing about encroaching unelected unconstitutional authority. I mean, just on the fringes, I don't know if anyone's noticed, but the Fed, who has some very clearly, the Federal Reserve, which has some clearly defined responsibilities, has got a bit of a mission creep going on. There's now talk of the Fed using its powers to declare various categories of industry loans, risky or high risk, is going to be using that to enforce edicts on climate change. So that, you know, that they tried to do this a few years back with gun manufacturers, and I think with payday lenders, and now there's talk of using it with fossil fuel companies, which is, I mean, that's gross encroachment, which I hope will not come to pass. But yes, I mean, the big threat is a supine Congress for failing to live up to its responsibilities.
Pat Malloy, I see you've had your hand up.
Yeah. John, thank you. And Elizabeth, thank you for your wonderful presentation. I was the general counsel of the Senate Banking Committee. So it's important for me to understand the Banking Committee has jurisdiction over IEPA.
Right.
And Sherrod Brown and Elizabeth Warren are on that committee right now, and they're major players.
Mhm.
It's very important to know which committees have jurisdiction over these pieces of legislation. And then there's one more that you didn't mention, the Defense Production Act is out there as well. That's Banking Committee jurisdiction. But normally that has to be renewed every couple of years. They don't give long extensions of the DPA, except for Title VII, which is CFIUS. That's not subject to falling out of action. Now, just one more thing. My understanding is that when President Nixon put the tariffs on in '71, because when we froze the gold and then
Formerly the Banking Committee.
he used the Trading with the Enemy Act. And then and so people didn't want to use the Trading with the Enemy Act. So you can only use that during wartime. And then they put IEPA in place to be used for what the Trading with the Enemy Act used to be able to do.
Exactly. So the Article 1 Act was referred to Senator Lee's bill, which requires Congress to approve national emergency declarations after 30 days, was referred to his GAC, to the Homeland Security and Government Affairs Committee in the Senate. And it was reported out of that committee on a vote of 12-2. So with all of even though it was a Republican bill, all 6 Democrats voted in support of it. This was back in 2019. During the markup, IEPA was carved out. So basically it said any national emergency declaration will expire after 30 days unless approved, except for national emergency declarations that rely on IEPA. So yes, so that is absolutely, jurisdiction is an issue with all of this. And the DPA falls into the category that I was referring to as sort of pseudo emergency powers, because you don't need an emergency declaration to use it, but it's clearly supposed to be an extraordinary power for extraordinary circumstances. So yes, I mean, a longer talk, I would have mentioned the Stafford Act and the Public Health Service Act and the DPA and there's a lot of other statutory frameworks. It's just that the National Emergencies Act is the most sprawling and in some ways, the furthest reaching. And then on the Trading with the Enemy Act, that was initially for wartime only, but it was expanded actually during the Great Depression and became so that it could be used for national emergencies or during wartime. And the entire purpose of enacting IEPA was to separate those and to say, okay, we're going to leave the Trading with the Enemy Act in place the way it is for wartime. But for peacetime uses, for national emergencies, we're going to put some more safeguards in place. And basically the main safeguard that they put in place for peacetime use was to put it under the framework of the National Emergencies Act, which then meant that Congress could easily terminate a national emergency with a legislative veto. I mean, that was really the big innovation, not innovation, but the big reform in the National Emergencies Act was the legislative veto. That was the main control that Congress gave itself. And then
unconstitutional.
Went out the window a few years later.
Yep. Thank you. Very helpful.
Lisa, can you explore a little more some of these relationships you've alluded to? So what is the relationship? You said that the war power is a subset of emergency powers overall, domestic, and we have domestic, foreign. What's been the historic relationship between the two? Which is feeding? Is the national security thing feeding the domestic? Is the causality more going that way coming in, or is it?
It's a really good question. Yeah, it's a really good question. I think they are, these days, I think anyway, they're kind of working hand in hand. I think there used to be more of a sort of bright line between sort of national emergencies, which were seen as sort of economic and labor more than anything. I mean, emergencies generally were declared around labor disputes. Domestic military deployment was most likely to happen around domestic labor. And then you had foreign wars, which were by nature, they were foreign. You didn't worry about sleeper cells in the United States in the first sort of couple hundred years of our country's history. So the division between domestic emergencies or emergency powers and foreign, which is war powers, I think was sharper. And now I think you see, for example, you hear a lot about trying to repeal the 2001 AUMF, Authorization for Use of Military Force, based on the fact that it was originally intended to authorize war against, hostilities against, Al-Qaeda and the Taliban. Essentially, that's more or less it. And that it's been expanded to authorize hostilities against groups that did not exist on 9/11 in countries all over the world. And so there's this idea of, well, we should be repealing the 2001 AUMF. Yes, but a lot of the work that is done under the 2001 AUMF could not be done without the National Emergency Declaration from 9/11, which is still in place. It's been renewed every year, renewed by 3 administrations, soon to be 4, right? And under the national emergency powers, that's where the president gets the flexibility to move the military around, to implement stop loss, to call the reservists into duty. The war in Iraq could not have happened. We just didn't have the manpower to do it without the National Emergency Declaration from 9/11, which is what they used to call up the reservists and to implement stop loss in Iraq, in a totally different war that had nothing to do with 9/11. So the emergency declaration there is doing a lot of work to support the war powers. So they feed into each other.
Right. The case that Bruce, it was when Truman tried to seize he tried to seize the steel industry, right? And that was where it was a foreign. He used the war power. It was a war power context.
Right, and what the court said there is the fact that you are the commander-in-chief of the armed forces does not make you the commander-in-chief of domestic industry.
Right.
The problem is how you grapple with, Islamic terrorism. The sort of the legal fiction is that people in this country who were inspired by foreign at war could be treated as enemy combatants even though they were inside this country. And so that just blurred the line between a foreign war and domestic war powers.
Yeah, the thing that you said that I think the most important thing you said tonight, for me at least, is where you saw the greatest danger in these limitless Article 2 constitutional powers. Caesar always has lawyers to tell him he can do whatever he wants, and so to me the relationship that's interesting is that with all these delegation, all these emergency power things, that the sooner we get Congress to do their job and pull these delegations back, the more difficult it'll be for a president to make these outrageous Article 2 claims to somehow inherent Article 2 power on emergency powers looks very different in the context of if we wipe out these if we pull back get Congress to do their job and pull back the emergency powers. That's the relationship.
Right. Yeah, no, I think that's right. And what's interesting, there's a wonderful article by Sai Prakash at the University of Virginia, and it's called The Imbecilic Executive, which is just a tremendous title. And he goes through the history of basically how presidents interpreted their authority, their constitutional authority to act during emergencies. And essentially what he said was there was this notion that the Constitution provided what it provided, and that in situations where the president did not have authority to act and Congress had not given the president that authority, that presidents would and did up to the Civil War, basically, and through the Civil War, would sort of do something anyway, something that maybe was not authorized by law, maybe even unconstitutional, but they would admit it. And they would say afterwards, yeah, I violated the Constitution, and I did it because it was necessary to defend the country. And they would throw themselves on the mercy of the public and Congress would either indemnify whatever the executive official that had broken the law or not indemnify that official. And that was actually a pattern. And then after the Civil War, that pattern changed. And so today, no president would ever say, what I did violated the Constitution, but it's okay because I did it for the national defense. Instead, what they say is, I did it for the national defense, therefore it's constitutional. And there's this notion now of an infinitely flexible Constitution that allows the president to do anything he has to do for the national defense. And that is, that's worse. It's better to say, yeah, okay, I didn't actually have the authority to suspend habeas corpus, but look, I had to do it to keep the country together. Now, Congress, are you okay with that or aren't you? Essentially, that's more honest and to me less dangerous than presidents saying, well, maybe the Constitution gives me inherent power to suspend habeas corpus. There's probably a DOJ opinion somewhere that takes that position.
Yeah. If I could add a footnote to what John asked, Lisa, and I'd like your observation too. It may well be that repealing the National Emergencies Act and these emergency powers will cause the president to rely upon Article 2. And I give an example. The Vietnam War, the Gulf of Tonkin Resolution was repealed by Congress in 1970. And William Rehnquist wrote an opinion and Nixon said, it doesn't matter. I have Article 2 authority to fight the war anyway. It doesn't make any difference. You may recall also that Barack Obama as president asked, he wanted a declaration of war because of the Syrian issue and the chemical weapons. And he went to Congress. They didn't even give him a vote on his proposal. And he went ahead and said, all right, well, ISIS is a problem and I can go ahead and use military force under my Article 2 powers. And what's stunning and alarming is that these claims have not been responded to by Congress with any kind of retaliation. They do kind of shrug their shoulders and move on. And if the courts are going to be as weak as you've described them, then we'll end up unwittingly in a worse position where now we've expanded Article 2 authority by default.
Well, I mean, sure. I mean, that's, are we going to negotiate with the hostage taker and say, well, okay, if you're threatening to do illegal things, if we don't make them legal, then I guess we have to make them legal. I think that way kind of lies madness. I don't think that's any way what that highlights to me is that there needs to be a way to unearth secret opinions to start with, to unearth whatever interpretations of executive power exist within the executive branch, make sure they see the light of day. And then the next step is to try to figure out a way to get those in front of courts and or try to get to Congress to I'm trying to use an expression that I can use on this call to do its job and to exercise the power of the purse, to attach actual consequences when the that's the answer to that, right? The answer to that is not, okay, carte blanche, do what you need to do through a legislative and open legislative delegation, because otherwise you'll do it anyway without a legislative delegation, and that's worse. It's not worse. It's not worse than an open-ended, inappropriate delegation of power. It just has a different solution.
So,
Liza,
Mark, come on, jump in here.
Thank you, John. Liza, could you give us a little more color on the PIADs, sort of the mechanics of these documents or memoranda and their legal status? Where are they sitting? Only in the White House? Has Justice opined on them?
Not a whole lot of public information, but they're developed under, as you may or may not know, as you can neither confirm nor deny, they are sort of the guidance of the National Security Council, but they involve whatever agencies are involved in implementing whatever the PIAD may be, depending on the subject matter. And so, the agency works with the National Security Council, with FEMA. FEMA is usually involved as well. And then the Department of Justice is involved in a legal review, not an illegal review, a legal review of the PIADs to make sure that it comports with their interpretation of the law. So it's not, I mean, the fact that they are withheld from Congress would make you think that we are talking about something that is so closely held that there may be only 5 people in the executive branch who have access to it. That is not true. Multiple agencies are involved and have access and know about these documents. Now, the documents themselves are not legal authorities, right? They are directives. They are in the same way that, an executive order that, I'm trying to think of an example, but an executive order that the Muslim ban, for example, that wasn't a legal authority. That was an application of part of it, or misapplication of the Immigration and Nationality Act, right? So it said, under the authority of the INA, I hereby do X. So all of these directives and orders claim to rely on some legal authority. And in some cases, it might be statutory authorities, but from what we know about some of these older ones, they must have been relying on claims of inherent constitutional authority, because there have never been statutory authorities that, by definition, there's no statutory authority that says the president can suspend habeas corpus without Congress, right? So we know that they rely at least partly on claims of constitutional authority. What else do I know about?
And continuity of government was supposedly the theory, right? That in the case of a nuclear attack or some other, right?
Yeah, initially. And again, not a terrible idea, although if you read Raven Rock, Garrett Graff's book, you get the picture that initially it was some sort of high-minded, we want to keep the country going, essentially, and we need government to keep the country going, and so we need to preserve government in some way, shape, or form. And then at some point it seems to have become, we can't save the country, nobody's going to survive, but hey, maybe we can. And that's, that's a cynical view of it, but the book.
Thank you.
So have we exhausted this secret, Bruce? Have we exhausted this?
One final question. This is, where does the authority come, Liza, to withhold the information from Congress? Classification began unilaterally by the president. There are a couple of exceptions for, I think, under the Atomic Energy Act. But is that another claimed inherent authority? We know that there are congressional rules that authorize Congress to declassify documents. The Church Committee did it regularly. And it was available to Dianne Feinstein to declassify the torture report, which she refused to do. But I just is your view that this is another claimed inherent authority that Congress also needs to address?
It is, but I would say, so the Supreme Court has actually, on this one, has actually weighed in and said that the president has authority under Article 2 to safeguard the authority and responsibility to safeguard national security information, executive branch information that could harm national security if released. Now, what the court did not say is that the president has exclusive, so he has inherent authority. That does not answer the question of whether Congress can legislate to in some ways put limits on that authority or regulate that authority. Because under Youngstown, it's their shared authority over certain things. And Congress can, even if the president has constitutional authority in a certain area, Congress can still put limits on it unless Congress itself is acting outside of its authority. So as long as, so that doesn't answer the question of whether or not Congress could be doing more. I think Congress could be doing more and should be doing more to rein in overclassification, generally speaking, but also to insist on more access by Congress to executive information.
Right. So, Bruce, do you want to take a minute and go through the two letters we've sent, one to Biden before he was
Yeah.
swore to uphold the Constitution, and the recent one to his Attorney General.
Yes, we sent Liza and everyone else who hasn't been privy to this. We view the war power as, in some sense, the most menacing of emergency powers, because, in my view, it legalizes first-degree murder. You can kill not in self-defense, and you need to use that power cautiously. And that was why the framers entrusted the power exclusively to Congress. And it's kind of ironic that the framers did anticipate emergency powers, because they said at the Constitutional Convention, well, if the country is attacked, there's a sudden attack, Congress, we've already broken the peace, the president can respond on his own. That was the one place where the framers said, okay, that's the emergency power. It's ocular evidence if we're attacked, he can respond. But we wrote a letter to Mr. Biden pointing out his position in 2007, running for president, which was categorical. If then President Bush attacked Iran, he would lead the charge to impeach President Bush for an unconstitutional war in violation of the Declare War Clause. And he emphasized that repeatedly on the campaign. And we now have ongoing, depending on whether you call wars against non-state actors, 7 to 8, 9 presidential wars. And we urged President Biden to comply with his own standards as he articulated in 2007, and state that unless Congress passes a declaration within a short period, he's required by his oath of office to withdraw the troops. We reiterated that general legal theme to then Attorney General designate, who's now the Attorney General, Merrick Garland, in a more recent letter stating that Mr. Biden's bombing of Syria, with which we are not at war, I guess to kind of retaliate against Iran, also we're not at war, was a violation of the Declare War Clause, and he should be advising the president. He has no authority to do that. And that's where that stands. We never received a response or even acknowledgement of receipt of the first letter to Mr. Biden. Mr. Garland may respond to us. But again, we underscored, these were Mr. Biden's own words, repeatedly emphasized with regard to President Bush, Iran, and 2007 campaign. So that's where we are. We're continuing to push on that front.
And he said it was a high crime and misdemeanor. Presidential war is a high crime and misdemeanor, and thus an impeachable offense. And in the interview with Chris Matthews, he let him walk it back, and he said, no, I've been head of the Senate Judiciary Committee forever and the Senate Foreign Relations Committee forever. I've taught constitutional law. I know the law. Separation of powers keystone is the war power, and then he repeated it in town hall. So unlike our last president, who I really seriously doubt whether he really ever had any concept of the Constitution, Biden clearly does. So it's we keep writing these letters, not because we think we're going to succeed, but because it's the right thing to do, and we don't really have an alternative.
Wanted to underscore that, Liza. Yeah, we're willing to collaborate. I certainly am. You're working on stuff. I know people have different bandwidths, and I have different experience in Washington than other people, but eager to help you in any way in your mission. I think we have an absolute convergence of aim and ambition here. So the more we can reciprocate, I think the better off everybody will be.
I appreciate that, and I'll take you up on it. And
we had a consensus on our board, left and right of center. Everybody was on board with House Resolution 922, which Walter Jones submitted, which made a presidential war a high crime and misdemeanor, and thus an impeachable offense. And then Tulsi Gabbard supported that. Then Walter died. Bruce and I went to his funeral in North Carolina because he was the only person who really took the war power, we thought, to the same extent, seriously. And then Tulsi then reintroduced 922 in the last Congress as 116 as House Resolution 411, and now she's gone. So we have the the language, and all we need is for Congress to do its job. And we need, how many sponsors do we need, Bruce, to make it?
No, I mean, all we need, you only need one sponsor to introduce the bill.
No, I mean, how many do we need to make it go to the Senate for trial?
Oh, all you need is a simple majority to go to the Senate.
So that's what is it? 200,
218, I think is what it is.
218.
Yeah.
So we're 218 votes short right now.
Is that all?
That's all.
Good Lord.
I think on like the Social Security bill that was in the last Congress, I think they were just 1 or 2 votes short. They had 215 or 16 co-sponsors on increasing Social Security, but we're 218 in the hole. So who else? I see we have David Shipler. David, you write on the Constitution all the time. Do you want to say something before we?
Yeah.
There you go.
Sorry, I don't have a camera working here. Well, Elizabeth, that was just a masterful presentation. Thank you. This is all pretty new to me, actually. I have written a lot about civil liberties, but the emergency powers issue is deeply concerning, and I think you're all really impressive in what you're trying to do. Let's hope Congress actually comes together and actually makes some change. I also I respect Bruce Fein enormously, and I understand, Bruce, your point about, in a way, opening the door to a worse situation possibly by reforming. But, this is a country that has to adhere to the rule of law. And if we don't have laws, all we have are men. And as James Madison said, they seek more power than they need to, and you've got to restrain them. So I'm just really very grateful for your presentation. And this is a great discussion, John. As always, you put on these tremendous salons, and I'm very appreciative. Thank you.
Well, we're only as good as the suggestions that we get from our members. And Tim, I really appreciate you taking the lead on this, and Joel and Mark. Mark, you had your hand up a minute ago. Did you still?
No, I was applauding. I was just applauding.
Okay.
That was an applause sign, not a raised hand.
Okay.
You kind of look the same.
Well, good.
Here, I'll give you a thumbs up. Here's a thumbs up.
Okay, good.
Joel has something.
Joel.
Yeah, let me ask one question. Elizabeth, you come to the dark side with me for a second.
Oh dear.
And
I live there.
You live there, okay. So let's go back to the transition period. And suddenly you've gone to the dark side, and the president asked you to come in, and you know what his intention was around January 6th. And he said, how do I get there? What's my roadmap to succeeding on January 6th and to taking power?
Well, wait, what date is it that he brought me in?
Well, I'd watch even earlier than that.
Well, before, so was this before or after January 6th? Before?
After what?
Maybe right before.
Or after January 6th. I think Article 12 was his way. If he was looking for a legal way to do it, it was convincing Pence that his role was more than ministerial. I think that was it for a legal way. If the states weren't going to, basically the legal doors one by one were shutting. And so, and at the point that Pence, and that was the last one, I think. There was at some point the possibility that states could just, the Constitution gives state legislatures the ability to figure out how electors are going to be chosen. And they could have, there's a statute that says they can't change the rules after the election, but what if they decided to do it anyway and said the Constitution lets us do that? I was worried about that. It didn't happen, right? And then, at every stage, as the legal doors closed, it wasn't until that last door closed that sorry to be blunt, but the crazies came out of the woodwork and said, martial law, insurrection act, emergency, this and that. And it was like this like autocratic word salad where they thought if you said all those things, then that's what, then it could happen. And somehow, and I actually have I asked a couple of my colleagues who work in the program that I direct, I asked them to write up, now that sort of it's all blown over, an explanation for why that was never going to work. For, why once a president has actually, there's a lot he could have done with emergency powers to try to sway the election. And I wrote it in the article I wrote in the Atlantic, whenever that was, a couple of years ago. But once it's over, once the votes are in, and once it's been certified, he's done. There are no emergency powers. Of course, there's the inherent constitutional, but even that, the inherent constitutional powers would never trump the express provision of the Constitution that says at noon on January 20th, he's not president anymore. So at some point, he was out of legal options, including the emergency options. All he had was a military coup, and which, whatever. I mean, what can you say about that? Except it didn't happen. But anyway, so my colleagues, Joseph Nunn and Andrew Boyle, published a piece on the Brennan Center's website last Wednesday, I want to say, basically saying, here's why all of those things, martial law, suspending the Constitution. Somebody said he should suspend the Constitution. All of the pillow guy's crazy ideas, all of the reasons why those actually weren't real ever. They weren't real. And I guess, again, I like to sort of close on hopeful notes. Statutory emergency powers are scary, but they're not limitless. It's not as if when the president declares a national emergency, he can do whatever, right? When he declares a national emergency, there are 123 powers out there that he can use. And some of them are scary, but none of them allows him to set aside an election. There is no such statutory emergency power, right? So at that point, he's either relying on some kind of crazy inherent constitutional power that doesn't exist, or he's going to the military coup route. Anyway, so I would, I can actually put a link to that in the chat. Maybe I will do that quickly if I can do it.
Well, that's a very optimistic way to end the session today. So thank you.
The optimistic part is me thinking I can find the link and put it in.
So have you drafted statutory language on all of these emergency powers that would limit it and bring it in reign? Have you gone through that exercise?
Not all of them, no. I mean, we're sort of biting them off. So we have worked with them. We worked with the lawmakers to come up with the reforms to the National Emergencies Act that are moving. In terms of the individual powers that become available, we've taken on IEPA. We have something coming out on that. And we are looking at the Telecommunications Act, which involves the internet kill switch.
So you're going at it piecemeal. You're going at it.
Yes.
One bite at a time.
One bite at a time for the individual. And as I said before, many of the individual powers that become available are not scary. I don't think they need reform, a lot of them. And so we want to focus on the ones that are really worrisome. But we want to start with the overarching framework so that whatever power is invoked, however it's being used, Congress can cut it off. And they can cut it off by doing nothing. The default is that it ends unless Congress votes to approve it.
Which they're really good at, doing nothing. So that's a
yeah. There you go. Here, I just managed to get that in. Oh, Mark, you beat me to it.
Yeah.
Anyway.
Okay.
Yeah.
Right.
And Elizabeth, the theory that Mr. Trump had, this was in 2019. These very ominous words are reminiscent of Frost-Nixon. Then I have Article 2, where I have the right to do anything I want as president. That's on July 29th, 2019. And Congress did nothing and didn't seem to cause people to be frightened. That was the most alarming statement ever to come out of the White House in the history of the presidency.
Yeah, I mean, a lot of what he said made no sense and wasn't true. And it just, you never knew. I agree with you. I think it would have been more alarming if it came from someone who I don't know. I was more worried, frankly, when Vice President Pence, and this was at the ceremony, not ceremony, but sorry, at the press conference outside the White House, one of the COVID conferences. And it was right after the president had declared a national emergency. But he said something then about how the president, he was basically saying that the states, that he could force them to open up, that could be his decision. And he said, when someone is president, his authority is total, right? That it has to be that way. The president's authority has to be total. Then I thought, okay, there goes Trump saying things he doesn't even understand. And then Vice President Pence got up and said, the president's authority in a national emergency is plenary, and we can brief that. That worried me. Pence is a lawyer, and when he's saying we can brief that, and he's using words like plenary, it means there's a Justice Department opinion somewhere, and that that worries me more than Trump shooting from the hip and saying things that make no sense.
I think everybody's learned so much, and thank you, Joel and Tim and Mark, and for joining forces here and bringing Lisa to our attention. And keep up the good work, and let us know anything we can do.
I will. Thank you. Thanks for this opportunity to speak to everyone.
Great talk.
Thanks, Liza.
Thank you.
Thank you.
Good evening.
Appreciate it. Thank you.